Hi everyone, my name is Ashley Jacobson. I founded and work at Jacobson Law and Advocacy in Michigan. I also work for Adaptive Inclusion that provides nationwide accommodations assessments and disability consulting services. And I am a proud disabled woman. I live with physical disability and work in the state of Michigan, but I often consult on cases all over the country and even internationally sometimes, which has been neat. But I wanted to create this video to talk about a niche area of the law that is really critical to the disability justice movement, but is not often talked about. And that is the abuse and neglect court. Now, if you've been a child through the foster care system, or you're a parent who has dealt with CPS investigations, court cases relating to that, I know that this can be a really heart-wrenching topic to think about. But it's really critical that parents and kids know their rights and that attorneys know how to competently address disability as it arises in these cases. Otherwise, you're looking at potential disability rights violations presently or down the road. In my work as an attorney, a lot of my cases overlap different areas of the law. And so while many of my cases are special education cases where I represent kids and their parents against the school, if we say the school hasn't provided certain services or if they've discriminated against a student, I have several cases that involve workplace discrimination as well, and juvenile court cases. Let's say I'm representing a child with a disability in a special education case, and they wind up acting a certain way in school. The school calls the police on them. The police or the school resource officer refers them to the juvenile court. And now the child is not just a foster child in the system. They're dealing with criminal charges on top of disability needs that aren't being met. So it very often intersects with a lot of different areas of law. But I've really seen how courts can be hit or miss with how they address disability in abuse and neglect proceedings. And that's why it's really important as an attorney that you know how to address these things and even how to spot them when they arise so that you can talk to your client about it. So when a client first participates in the abuse and neglect court system, and again, check with an attorney in your area because every state is a little bit different. This is educational in nature, not personal legal advice. Always check with an attorney if you have personal legal questions. Okay, now that the disclaimer is again out of the way. When a parent first encounters the abuse and neglect system, it's usually when a CPS worker reaches out to them or shows up on their doorstep. And this is usually a social worker or someone similar who says, hey, listen, we got this call, not a big deal. We have to go through the investigation, check a few boxes to show we looked into it. I'm sure everything's fine. If you just talk to us, we can smooth this over and resolve it, and then we'll be on our way. Then the parent says, oh my gosh, I know I'm a good parent. I can't believe that this is happening. I just want to get this done and over with as soon as possible. So of course I'll talk to you. Typically, it is wise to wait for an attorney to be present or at least to consult with them before you give any statements to CPS generally. But from there, then the CPS worker or investigator is asking questions like, have you ever suffered from mental illness? Have you ever been diagnosed with any disabilities of any kind? What are the symptoms of those? What are the medications you're on? Do you use medicinal marijuana or not? Do you use recreational marijuana or not? Who oversees your medication? Can you sign a release allowing us to talk to your doctor? So a lot of really invasive questions are asked in really casual ways sometimes in these meetings. And so parents think, if I just explain myself, this will go away. But from there, if the CPS investigator or the Department of Health and Human Services or the prosecutor's office in your county decides to file an abuse and neglect petition against you, the next thing you know, you're going to court for a preliminary hearing or something similar in your state where they've have to determine if there is enough evidence there, if it's more likely than not that one or more things in the petition, the allegations against you, if one or more things are likely to be true, then the case is authorized and moves forward to the next phase. And often it's at that point where the person realizes that they really need an attorney and they ask for one. And in many states, you have the right to a court appointed attorney um, to assist you with that. And I know a lot of people say that court appointed attorneys don't have the best reputation. I have seen them be consistent across the board, similar to other attorneys. So there's some good ones and some bad ones, but I've seen some really exceptional court appointed attorneys, some who were my mentors, are my mentors, who I have a lot of respect for. And I also have private cases and I have court appointed cases. And a lot of attorneys do it like that. So that being said, when you have a case initiated against you by CPS, DHHS, the prosecutor's office, it's at that point that it tends to become really overwhelming for the parent and for the kids. That's when they start looking at, do we need to ask the court to remove the kids from the care of the parent? And what are the reasons for that? And is there an emergency need for that? And very frequently in those discussions, I'm hearing other attorneys, guardians ad litem, the judges sometimes making reference to a parent's disability, their history of mental illness, when determining if children should be immediately removed or if children should be returned to the care of a parent. And even in cases where the parent is thought to have a mental illness by the caseworker, the CPS worker, but doesn't, I'm still seeing that have a discriminatory effect on the parent because people assume that there's mental illness there and they assume that a parent can't be a good parent with mental illness or other forms of disability, which is absolutely not the case. Are there different supports that we might want to engage in? Sure. Are there certain things that we might need to accommodate throughout the court process and parenting time and all of that? Yes. But I often have to check the other professionals, not many of the attorneys I work with who are wonderful and who are also on the ball about this, but often like caseworkers and even some referees and judges in other, counties on we need to make sure that we're not overly dissecting this parent's disability because we're assuming that because they're disabled, they aren't capable of being a good parent or a fit parent. But I'm seeing a lot of also parents in the abuse and neglect court system essentially say, I'm willing to go through this abuse and neglect process, get the services out of the way, show them I'm a fit parent, and then a year later, 2 years later, 3 years later, we're still in these court cases because other people are making assumptions about that parent's parenting ability simply because they have a disability. So you want an attorney who can understand how to address these things head on. Some of the comments that I'm hearing made, things like, well, the parent doesn't work because the parent's on disability benefits. Their job is to take care of themselves because they're unable to sustain gainful employment. Does that mean that they're a bad parent? No. But often we'll see the not working being used against parents with disabilities. Sometimes it looks like a foster child who we can't find a foster family placement for. So we place them in a secure facility. And in that secure facility, they aren't receiving proper special education services, or they've gone without their eyeglasses for 4 months. And so disability can pop up in that way. Disability can also pop up when we're looking at cases where the prosecutor's office, DHHS or CPS, are trying to terminate a parent's rights. And sometimes it's a goal of reunification. Sometimes it's a goal of terminating the parent's rights. Sometimes they have a goal of trying to set up a guardianship because they don't trust the parent with a disability to parent on their own. They assume that they might need a guardian to support them and to provide that extra care and custody for the child. But a lot of assumptions are being made very early on in these cases. And that's why it's really crucial that it is wise to speak with an attorney before speaking to any CPS investigator. Because while the abuse and neglect court system in many states is a civil court system, meaning you're not pressed with criminal charges, but you can have your parental rights taken away. And that's why they allow you a court appointed attorney, because those parental rights are constitutional rights. But long story short, um, they're making a lot of some assumptions about the parent, usually a parent with a disability. And they're saying, we don't believe that this person is a fit parent based on the fact that they have a disability, they had an IEP in high school, they have a history of mental illness, even though it's well managed now. And so, as an attorney, you want to delicately and respectfully, but sometimes zealously, say to the court, I'm hearing a lot of discussion about my client's disability. We assert that my client is a fit parent, that her disability does not affect her ability to parent. And we're concerned that so much of the focus being on her disability speaks more to our lack of understanding and awareness of disability issues. And we want to make sure that the process is accessible to her and meets her where she's at. And in my state, one of the case law pieces of case law that we use is for a case called In Re Hicks Brown, where they basically say it's required to do that. For a parent with a disability, you're required to provide reasonable accommodations and to make sure that the abuse and neglect system and the court process overall is accessible to them. And, we want to make sure that we're going into these court hearings knowing this type of case law in your state so that you can address it. And if in the hearing it's not addressed in the way that you think is the most appropriate, then you want to at least create a record so that you can either appeal that decision or submit a review of the referee's recommendations to the judge, something along those lines. But abuse and neglect cases are gut-wrenching for any parent and child. But I've really seen it take a toll on parents with disabilities because there are a lot of assumptions being made about them that aren't true. And with simple support or investigation, a lot of these court processes could be avoided and prevent trauma to the child as well as the parent. I think a lot of people also sometimes hear of abuse and neglect and they think, well, I would never have to go through this because I'm a great parent. But I've seen really great parents, based on a simple misunderstanding, find themselves in the abuse and neglect court for years. And so you want to take it seriously if this happens to you, and you want to make sure that you reach out to an attorney who has a good understanding of these court systems, because a lot of the abuse and neglect courts are really insular. That a lot of the attorneys, we work together very frequently, and we know these judges in our area. We know these referees. We know how we think they're going to be receptive to certain things or not. And so you really want to make sure that you don't delay seeking legal assistance if this happens to you, but know that if you have a disability, you have some additional rights in the abuse and neglect civil system, and you have additional rights if you're charged criminally. And that's another reason why you want to speak with an attorney right away as soon as you find out that CPS wants to talk to you, because anything you say to that worker could also be used against you in a criminal proceeding. So you could be facing abuse and neglect civil cases where they're trying to either remove your children, terminate your parental rights, set up a guardianship instead of having you be the parent, whatever that goal may be, while you're also facing potential criminal charges, which could take away your freedom. So you don't want to lose your parental rights. You don't want to lose your freedom. Of course, you want to make sure that your child or children are not traumatized throughout this process. And that's why I wanted to talk about this today. And if anybody has any questions, concerns, you want to reach out to me and you're in the state of Michigan, feel free to contact me at 248-878-6940. You can call that number, text that number. It's also available for RTT for people who use that assistive technology device. And you can also reach me by email, Ashley, ASHLEY at JLAPLLC.com if you have any questions or if you're another attorney and you want to talk about this some more.